What's up, everybody? Welcome back into another episode of The Lawyer You Know. We are talking Karen Reed, and we're going to get an update from an attorney who's been following it. You guys have seen his stuff on here and everywhere else. Mark Bederow, who is involved in the case and outside aspects, but been following it pretty in depth and has a lot of thoughts on how this case is being tried from each lawyer. He has thoughts on the lawyers, thoughts on the judge, but most importantly, thoughts on some of the witnesses and how lawyers look at witnesses that have testified over the past couple weeks, and how you, as a prosecutor, he was a prosecutor and now a criminal defense attorney, how you have to connect the dots, tie a bow around the case to actually prove this to a jury beyond a reasonable doubt, and how the defense attorneys can poke holes and have some other theories of their own. So we're going to get his thoughts on an update in Karen Reed's trial number 2. Mark Bederow, welcome. Been a couple weeks since you've been on. A lot's happened. I want to focus in on kind of a few witnesses and some trial strategy from the lawyers and what's going on, because the reports I'm hearing, I don't know if you've heard anything else, and reporters are there. Karen Reed's giving comments at the end of every single day, but it sounds like the Commonwealth is almost done with their case and may only call one more witness, is what I've heard the reports are. And obviously that's going to be Dr. Welcher, the accident reconstructionist, potentially the most important witness in their case. What do you think, knowing that they're winding down their case? How important is Dr. Welcher? And do you think it is even possible for the Commonwealth to overcome the reasonable doubt that's been highlighted by the defense thus far?
No, I don't, unless Dr. Welcher just razzles and dazzles and wows with science that you just can't comprehend going into this. The problem with him is he works for Aperture, and the jury is going to hear that within 3 minutes of him taking the stand. And that firm has already been, to some extent, pretty discredited by a lot of not so good things related to this Shannon Burgess. And then the other problem with Welcher is that he is relying upon Burgess's data as a kind of a factual predicate for whatever he's going to tell the jury. And if the jury has any doubts in the reliability or credibility of Burgess and Welcher, no matter how impressive he may or may not be, if he's relying upon data that they have reason to doubt or discredit or question, then anything he says could be fundamentally subject to being deemed not credible. And there's a problem there. And I thought, one of the interesting things that you saw from the cross-examination of Burgess, and this is beyond, stuff related to his academic dishonesty, which is devastating in my view. That's a whole nother topic. That the report of Welcher is entirely premised on Burgess's now admittedly incorrect, according to him, data that he has now since shifted and moved the goalpost 20 to 30 seconds, whatever it is. And Welcher apparently doesn't have a report that considers that, and presumably now is going to have to come in and say, well, I agree with Burgess, and this is what my studies will show in terms of timeline and accident and whatnot. I guess we'll also have to see how impressive his reconstruction is as it relates to the impact, where it could have been, how it would be that John O'Keefe would end up where he ended up, how the taillight would end up wherever it ended up. Whether any damage could have been caused by Karen backing into John O'Keefe's car at 5 o'clock in the morning. It'll be interesting to see. But even if that's overwhelming, I think they've got so many flaws in the case that some of their experts have established in the past week that I don't know how they're going to get past that with the burden of proof.
Yeah. And so I'm going to come back to that after we talk about a couple of these witnesses, because I want to see if there's some things we can talk about that may change your mind or open up a little bit more of a possibility. And by the way, I may not even agree with what I'm going to say, but just for discussion purposes, I do think it's interesting to think about what Welcher could do to try to tie a bow on this for the Commonwealth. You mentioned Burgess. The defense very obviously used Burgess foundationally to try and attack Welcher before he even took the stand. For the reasons and strategy you have already mentioned, if they can really crush Burgess, that will help them at least partially crush Welcher. And I'm sure they're going to have more work to do on him as well, as the research they're doing is going to be second to none, as we've seen throughout this case. So Burgess basically, if I want to drum it down, simplify it, dumb it down, and if I'm a prosecutor and what I want the jury to get is he just looked at some phone data, he just looked at some Lexus data, he matched up some clocks that say Karen Reed backed up her car at 12:31 or 12:32-ish, and she went home and turned off her Lexus at 1:42-ish, and all of that lines up with John O'Keefe's cell phone is never used again or human interaction after 12:32-ish. And it's as simple as that. Whether he went to college or not doesn't matter. Whether he said currently pursuing or didn't, that doesn't really matter. How do you think the Commonwealth can try to get a jury, or do you think it is possible that there are some jurors that think of it that simplistically, that it's just the data? They crush that. I feel bad for them, but the timeline somewhat fits to what the Commonwealth is saying.
I mean, that's what they want to do. And obviously, we don't know who the jury is and how they think. But I think the problem they have is it's not that the timeline is 12:31 or 12:32-ish. We're talking literally every single second. And not to sound all dramatic, but in this timeline, every second does matter, because if there is a crossover in their data where John O'Keefe is using the phone at a time where it's possible that the accident had already happened, assuming you believe there was an accident or an impact, I should say. Even, all the medical people seem to agree that the phone can't be used once the alleged impact occurs. So every single second matters. And the problem with Burgess, I think, goes beyond the academic stuff, which I'll save for last. You have, he's supposed to be a technical expert and just be kind of a techno nerd with cell phones, car telematics, and all that other stuff. And, he didn't know the difference between bytes and bits. Now, that's over me. I'm not a scientist, or an expert, but that seems to be, in this field, the equivalent of people like you and me understanding that 2 + 2 is 4. The difference between a byte and a bit, when you're talking about how much storage space can exist in some kind of electronic storage device. That's an issue. I mean, that's just basic competence. And then, you pile on top of that, he did this wonderful timeline about what was happening on January 29th of 2022. And it turned out that he had it on January 30th. Now, that is indicative to me of someone who's careless and doesn't pay attention to detail. It doesn't mean that he was off a day, he made a mistake. That may not change the actual minutes and seconds. He just was off by 24 hours. But when you're already considering you don't know the difference between bytes and bits, you're not paying attention to what day it is, that is another, to me, indicia of just carelessness or base level competence. Then you find out that he is admitting that his initial data is inaccurate, which is, another example of possible unreliability. He's saying, I did it initially and then I changed it later. It turns out the change that he made was in the middle of trial, after witnesses had testified that had already kind of severely damaged the prosecution's timeline. All of that looks not good for any expert. And then you get to something that I've never seen in 26 years. I've literally never seen anything as absurd as a prosecutor calling an expert witness and clearly, deliberately avoiding reference on his direct examination and building up his foundation to his academic credentials because he asked about every other credential. So he clearly knew. It was put on cross-examination that you weren't asked this on direct. So the jury, not only do they know that Burgess has these problems, but they know that Brennan was trying to sneak a fastball by them by ignoring it, which I think was a huge tactical error. It's a betrayal of trust with the jury, which is a constant problem, I think, with Brennan. in the past and certainly on this issue. But then you get to the actual merits of the academic problem, and you have him claiming that he has graduated in 3 different years. You have him claiming, well, really, that was just designed to show anticipated graduation, but I didn't do it that way. Then you have him claiming that he's currently pursuing a degree that he's been pursuing for 17 years, which is unheard of. I don't care that he doesn't have a degree, but it appears that he's misleading about even currently pursuing it. And then, if that's not bad enough, you have him on certain occasions indicating that the degree that he either claims that he has or is pursuing literally doesn't exist in that university. And, he didn't really own this, which I guess I understand. He kind of blamed his employer really just for doing that. And all he did in the process, I think, was destroy his own credibility. And as we talked about, really lay into Welcher's credibility, because this firm, if you accept anything what Burgess was saying, there seems to be a lot of sketchiness going on with this firm, certainly a lot of incompetence, a lot of failure of due diligence. But, you factor this all together, and how reliable is this guy? And I just don't know that certainly 12 jurors are going to give him a pass for what appears to be rampant and pervasive misrepresentation of his credentials, screwing up basic bytes and bits data, screwing up the timeline, being off 24 hours, admitting that he was wrong in his initial analysis, and then looking at them with a straight face and saying, you know what, in the middle of trial, I determined to look at the defense report and they got it wrong. And lo and behold, now look, it's going to help the prosecution in the middle of trial. I mean, you look at all of that, I just don't know who's crediting that guy.
Yeah, unfortunately, as I'm sure you have too, I've had trials where we've destroyed some expert witnesses and the jury still kind of tries to simplify it and say, well, no, it fits in, especially if it's a criminal case with a prosecutor expert. And that took you probably, 7 or 8 minutes to give that summation to crush his credibility, right? And we're talking about a case, just thinking like a lawyer knowing what's coming. She's limiting their closing argument time period.
Well,
you didn't even talk about Proctor. You didn't talk about the glass. You didn't talk about Welcher. You didn't talk about your witnesses, your ME, your accident reconstructionist, your people that are going to poke holes, Dr. Russell, dog bites, dog scratches. I mean, what are you thinking if you're the defense attorney given the closing argument in this case with such a limited time period? How do you pick and choose which parts of the Commonwealth case you're going to focus on to crush?
Well, I mean, you obviously have to pick on the big stuff.
Yep.
And to the extent possible, you have to link it together. Obviously, if you can kill multiple birds with one stone. I mean, one example is this. Take this, for example. Now they're moving the timeline of the accident forward 30 seconds to, I don't remember the exact time, but let's just call it 12:32, I believe.
Some change. Yeah, it was 12:31 and some change to 12:32 and some change.
Now you have a certain text message from Jennifer McCabe, which becomes, really interesting, right? I mean, she has that text message around that time, 12:31, 12:32, where she says, pull behind me, or pull behind whatever.
Yeah.
And where does that fit in with this timeline? I mean, they've got her basically looking outside while the accident, for all intents and purposes, is seconds away from happening or about to happen. And the other problem is, if the prosecution's theory is that the impact of the car occurred right in front of the flagpole, basically, and backed up 60 feet, then that means the car would have actually been way up the street in front of the neighbor's house. I don't even know if they would see it from the Albert window. One of the problems to me in doing the crime scene visit so early in the case, these are things that they're not even comprehending when they look at the crime scene. But, now all of a sudden, Jennifer McCabe's testimony becomes even less credible by them moving the timeline. We know she switched the timeline from the first trial. I saw him at 12:45. That can't be true, obviously. So, yeah, you have to pick and choose, work together as much as you can. But I think this is important for them because, obviously, if the defense can establish a reasonable view that the accident may have occurred at a time before John O'Keefe's phone, in other words, John O'Keefe's phone was still moving after the alleged timeline of the incident, then, I think that is a guaranteed acquittal. I mean, he cannot have been using the phone if he had been mowed down in the way that he was mowed down. And all the medical experts have said he probably would have been immediately incapacitated and not doing anything on his own.
So not actually what the medical examiner, or not the medical examiner, what the neurosurgeon said, right? He didn't say that. What a win for the Commonwealth. He did not say that he would be immediately incapacitated, because he said the very brilliant neurosurgeon who did brain surgery yesterday, who's doing brain surgery tomorrow, who makes his wife a cup of cappuccino every morning at 6 a.m. He gets up at 4 a.m. He's not immediately incapacitated because as cavemen, we could inadvertently or whatever, while we're asleep or even our brain has stopped working, could make movements like this and what. It's like, okay, yeah, but he's not taking 36 steps. He's not looking at his cell phone. He's not hitting the lock, but like, come on. It's like,
you stole my thunder. What I was going to say was, I mean, the stuff that he was talking about, I mean, isn't that like similar to when people get these severe concussions and they go into the fencing position? I get it. That's all subconscious, but whatever. But we're talking about, according to Ian Whiffen, taking the phone out of a pocket state, pulling it out, using Face ID, checking messages, and manually locking it. I mean, that, I think, strikes me as absurd. And I think the other problem with the neurologist, who is a real expert, I mean, in many ways, it's unfortunate for the DA that they called him right after Burgess, because it's a real.
How important is education? How important is it really?
I mean, but the idea of a professional expert and who are we kidding type expert. But the interesting thing about the neurologist was, working backwards, there are injuries on John O'Keefe's face, which he said could not have come from smashing himself backwards onto the ground, but they're injuries that he observed and exist, which means they had to have gotten there somewhere else. And I mean, that plays entirely into the defense theory of something else had to have happened to him. The other thing that he said, and I think this is another example of perhaps Brennan getting too cute with witnesses by asking him about, practicing in Minnesota where it's real cold, and he's trying to imply, could a hard surface, frozen surface, if you will, cause the head injury? And all he did was walk into, well, yeah, I see drunks all the time who slip and fall, which, by the way, is not a crime. And he's saying that's a common thing. And this is right on the tail of a medical examiner called by the prosecution who said, I can't even tell you this was not an accident. I mean, we're at a level where the prosecution is about to rest their case, and their own medical witness has said, I can't even tell you, forget murder by Karen Reed, I can't even tell you that this was a homicide, another person causing the death of another person by any means. That's
to
not
me,
good.
The brain surgeon was such a great, just for people to watch, people watching this trial who have heard maybe me, you, anybody complain about some of these experts, but say the bar is low. Judges let experts all the time. That probably shouldn't be. Here's what you want in an expert. And we try to explain it. And ARCA's a pretty good expert. ARCA's are really sound experts with great education experience. Hired guns, though, they work for a company. This is what they do for a living. This guy is like, see, you don't have to be a hired gun. 1% of his income is from this. He does brain surgeries all day. And guess what? What he's talking about is a brain injury. He's not trying to talk about other things. He's trying to talk about what his specialty is. Unlike Burgess, who I think would have answered any question Hank Brennan wanted to ask him, he would have tried to give an answer to show, I can answer that. I can help you. Please hire me on another case. And that to me was such a great contrast of experts, like you said, for multiple reasons, but also multiple ways unnecessary. Because if you look at the ME and you look at the brain surgeon a better expert, but they basically agreed on everything. That type of head injury can happen from blunt force trauma, hitting your head on frozen ground, or on a ledge. Not necessarily has to be a ledge, but could be a ledge type object. The injuries to his face did not come from hitting his head on the back of the ground. They agreed on that. Both of them agreed he's basically incapacitated, and except some movements he couldn't control basically right after this incident happened. Both of them said there were hypothermic tendencies, which was good for the Commonwealth. The defense, of course, had their questions, but both of them agreed hypothermic tendencies. Both of them also agreed that this was not, neither of them said this was consistent with a car accident. Neither of them were asked to match up the scratches on John O'Keefe's arm with the taillight. Now, the neurosurgeon, probably not a good question for him. The ME, they absolutely could have asked. You've seen car accident deaths. You've seen people get hit by car accidents. What type of injuries do they normally have? Is this what they normally look like? Look at these scratches. Here's what the taillight looks like. Did anybody ask if they could show you the taillight to line? They completely ignored it. Just like they completely ignored with Burgess, the 1236 Karen Reed's phone connecting to John O'Keefe's internet. Why didn't they ask Burgess about that? Why couldn't he explain that? Just like they didn't call Proctor, they didn't call Higgins, they didn't call the Alberts, they only called Jennifer McCabe, nobody else really that was inside that house. They are simply ignoring bad facts, and that's the defense's job to highlight. They've got to highlight 1236. They've got to highlight the scratches on his arm. They've got to highlight the fact that they didn't call Higgins and Albert or and Proctor. And, that's basically a defense's job in a case like this, to where I think the Commonwealth does have some consistency in some of their testimony, and they might be checking some boxes, but that's partially because they're ignoring all the bad stuff.
So I think everything you just said raises a fundamental question that should have been asked maybe 3 years ago rather than now. I mean, we're just talking. Obviously, we can address anything we want at any time. But if you have a medical examiner who isn't even going to tell you that I can conclusively, to any degree of scientific certainty, opine that this was a homicide, okay? If you have a neurosurgeon who can't tell you anything other than, yeah, it's a blunt force injury. Sure, it could be from falling down, but it could be falling down any on the grass, on the staircase, on wherever. He can't account for these other injuries, which I think is devastating to them. I mean, I think that kind of neutralizes any value the prosecution gets out of him, that there's other injuries. So the real question to me is, where but Norfolk County would anybody proceed with this? And again, it doesn't matter whether they think
Well, Mark, stop. Because years ago, before Welcher, we don't have to hear Welcher. Okay, you've read the ME's report. You see it's not a homicide. You see what she says about the injuries. But what if I present to you Trooper Paul, who walks into your office as the prosecutor who's making the charging decision, and he explains to you exactly how he explained trial one, that this is why we know and can prove that John O'Keefe was hit by a car, because that's another element that they had years ago when making the charging decision on this case. Sure, the ME can't say it was a car accident, but we have Trooper Paul. How do you evaluate that legitimately? Like, I know there are jokes about Trooper Paul, but legitimately, if that's the evidence presented to you as a prosecutor making this charging decision, what do you do?
I'll tell you what you do. I mean, certainly a prosecutor acting in good faith is seeking justice, not convictions, no matter what. And that's a decision that can come at any time. That could come in the middle of trial where you say, oh my God, we didn't do this right, but we have to do the right thing. And to me, the line in the sand, even if you accept Trooper Paul just as a self-serving prosecution witness in the investigative phase of the case, there comes a point in time when the United States government says, we're turning over a ton of material really to the defense, to both sides, but they're doing this really because they feel that we, the federal government, have exculpatory evidence that in the interest of justice, the defense ought to have. That is a red flag. It doesn't mean you have to dismiss the case right then and there. But when the feds come in and say, we're giving this to the defense, any sane prosecutor at that point would say, what's going on here? Okay. So they both get the materials. And what do you see in the federal materials that they get? The first thing, just to follow up on what you said, they see the ARCA report. Okay. Mm-hmm. And these are real experts, not Trooper Paul expert level. I mean, again, on the one hand, the prosecution has a boy expert. The defense or the federal government has men. I mean, these are professionals. And so you see that, wow, these are real accident reconstruction people who offered an opinion that, for lack of a better term, this could not have happened. Not literally couldn't have, but real strong opinion that the injuries to the car and the human being don't match up. Okay. Then you look at the other things that are in the federal materials. You get all that stuff about Proctor. I mean, you get all the messages, all the bad stuff, the discussion about the bribery, the stuff where he's pushing the medical examiner, the horrible personal messages, everything. And then you realize, okay, you have these ARCA guys who are saying there's no impact, that the taillight pieces probably would not have come off in that way. Now we have kind of a real dicey trooper. Okay, this is bad, but there's a lot more. Then you start realizing when you look at the federal materials, you have witnesses who are backtracking on major, major facts. Okay, Kerry Roberts testifies in a state grand jury unequivocally. Never mind what she said at trial. I was confused, or if the grand jury testimony was, I heard Karen Reed ask Jennifer McCabe to do this Google search. Okay. And when she spoke to the feds, several months later, and they gave her the 1,001 warnings, what did she say? She unequivocally walked away from that, intelligently, by the way, and said, I never heard that. Okay. That's a red flag, because Kerry Roberts said that in the state grand jury in April of 2022. And if she didn't hear that, why did she say she did? Where the hell did that come from? It's obvious where that would have come from. Her new friend, Jennifer McCabe. Then you look at her in the federal materials that the state got. You look at Jennifer McCabe and you realize this is somebody who's supposed to be cooperative, mourning her friend, no reason to be doubtful of anything. And what happens? The FBI comes up to her and she says, I'm Nicole Albert. Well, okay, that's a little weird, but they didn't identify themselves. Okay, they call her back. Fine, I'm going to tell you my name. I need to go make a few phone calls and brush my teeth, apparently was the story. And then you find out that she absolutely, unequivocally lied to the FBI. No question. She made all kinds of suspicious phone calls in those 10 minutes. Then she comes back. She's got nothing to hide. She wants justice for her friend, all of that. And as is her right, absolute right, she terminates the interview with people trying to find what happened to her friend. That doesn't make much sense. That's actually consciousness of guilt. Then you look at Higgins, right? And you realize this is a guy who got a lawyer, and, didn't he tell the feds, it came out at the first trial, that some man did come in the house, 6'2", brown hair, matches the description of John O'Keefe. All of these materials, to get to the point 10 minutes later, if you'll allow me, is you as a prosecutor, it's obvious what you need to do. You need to call a timeout. You need to basically say, this is serious. We're not ready to dismiss, but we have a ton of work to do to make sure we're doing this right. Okay. Do they even attempt to speak to the ARCA people? No. Why not? Any sane prosecutor would have been concerned and said, we need to know, are these guys credible or not? They made no effort. They would have gone to Proctor. They would have looked at all these things. And instead, what they did was go into court a week or two later, whatever it was, and say to the judge, we've reviewed all these materials. There's nothing exculpatory here. This is all a sideshow. We're ready for trial. And so it's at that point in time for me that the line in the sand of that these are not serious prosecutors. They're not pursuing justice. They're pursuing a conviction of somebody that they're all in and invested to for whatever reason that may be. And that's indefensible. There isn't, in my view, any other serious prosecutor in the country who would not at least be troubled by this information and attempt to confirm or dispel before proceeding. They did none of that.
Yeah, I don't know if I would agree that there's not a prosecutor in the country. Maybe what you said would attempt to dispel and look into it, but there are prosecutors that definitely go forward on cases and that I would disagree with on what they have. So that does happen, especially high-profile cases. Want to make a name for yourself, working your way up. That age-old story still does happen. I don't know if that's what's happening here, but I agree with you. Like, and when I called ARCA hired guns, I mean they're professional experts. Clearly not defense hired guns, since in fact the federal government had them under contract and they work for prosecutors all the time.
Right.
I just mean they're professional witnesses, comparing them with Dr. Wolf.
I don't think, no, you're not. They're just, that's what they do. They testify all the time.
But what else is interesting to me is it's really unusual around here, federally or state, for state prosecutors, unless they have an ongoing contractual relationship with an expert firm, right, that they use for all of their cases. It's really unusual for them to go out of state to Texas to find some other expert that is not the MSP reconstruction expert, that is not the ARCA expert. So it's like the third opinion they're getting, which makes, lawyers look like people say lawyers are. We just find an expert that says what we want them to say. That's what this looks like. And you can say what you want on the defense side, much more common on the defense side than a prosecutor to do stuff like that. We've had cases, as I'm sure you have, with insanity defenses where our client has admitted to ending somebody's life, and we have an expert that says he's insane. The state's expert that they always use says he's insane. Sometimes we get a third, combo expert that also says he's insane, and they let him go.
Yeah,
because that's how the law is.
That case recently, it happens where, if somebody's being honest to the process, sometimes it's hard to accept. Somebody admits killing someone.
Yeah.
But, they're legally insane, and they say they're going to a hospital instead of a prison. Here, look, as far as the cell phones go, the irony is, in my experience, if the state has problems and they need help, who do they call? They call the Justice Department. The DA couldn't do that here for obvious reasons, because they're actually adverse to the Justice Department, which again is another red flag of what are we doing here. But you look at as I said, it's no intentional smear of the experts, but it's as if they put out RFPs to find anyone willing to tell them anything. They have one cell phone expert who, they got from Western Canada. Again, that's not a smear on Canada. That's just bizarre. And they end up hiring a guy who has his own program, which just conveniently changes the dynamic to support their conclusion. It doesn't mean he's right or wrong without more, but that's weird. Their other cell phone expert, they hired off the internet. A DA's office literally making random calls, putting out emails. Again, that doesn't mean that her opinion is right or wrong, but that's weird. They have to abandon Trooper Paul because he's such a disaster. So they end up with Aperture, whatever, who we recently learned have a large footprint in Massachusetts from the Massachusetts State Police. One of their primary principals apparently is connected to there. I guess that makes sense in terms of the real business world. But even when you go with Aperture and they say, well, our guy, who's going to conduct the data testing for you, it turns out he's a disaster in terms of his academic credentials and his reporting about them. This is close to the case of the century. It's certainly the biggest case in that area in however many years. Where are the real qualified, unimpeachable experts who have no baggage and can just come in and say, look, this is what the data says. This is why. You look at a guy like Burgess, I don't even think, unless I missed it, putting aside any issues he may have with his academic credentials or some of the other, mistakes he made, bits and bytes and timeline, I don't think he ever even explained the variance in terms of just anything other than saying, well, it's generally accepted that there's clock drift and you get up to 60 seconds. But he never explained.
Everybody knows, your clock on your watch is different than the one on your microwave. I
don't know that. Okay.
Well, it's because I set the one on my microwave. That's why it's wrong half the time.
Well, and I thought that was a terrible example that he used, not you.
Yeah.
Because a microwave is manual. Okay.
Exactly.
Of course that's going to be wrong. But when I'm talking about my iPhone, my computer, I guarantee you right now, my iPhone has the exact same time yours does, because it's just the way it is. And I don't think he ever explained anything other than, trust me, bro, basically, there's a clock drift. And I'm not necessarily trusting a guy who lies or misleads about their academic credentials, or alternatively, is too careless to even keep your eye on it over the years, who tells me he's pursuing a degree, but in reality is not. He took some college courses. That's the truth. You're not pursuing a degree. It sounds like you saw yesterday, it was reported he hasn't been in a classroom in over 6 years. That's not pursuing a degree. So I need more than just him saying there's a generally accepted variance and just trust me. And all I have to do is line up a few things and presto, it all works. That doesn't sound like science to me. That just sounds like a data analyst to me who says, I believe these things are matched up. And there's another interesting point to this, and I don't know if the defense is going to jump into this or not, but one of the key incidents that he used to line up the clocks, if that's the right term, was this 3-point turn. That was the trigger, the first trigger of the two, which I think he said occurred at 12:23 or thereabouts, and it occurred on the other street. In other words, not on Fairview. I think it's Cedar Crest or whatever.
Right. They passed Fairview, 3-point turn, came back, which is why they were turning the opposite way of Maple.
In other words, not in front of the Albert
residence.
Well, there's a funny thing, because Matthew McCabe told the state police shortly after Karen Reed was interviewed by the state police and said, I made a 3-point turn, which she admitted in one of these clips. I don't think that's an issue, right? I mean, that's nobody disputes that. But Matthew McCabe said, I was looking out the window at Fairview around the time Karen was there, and I saw tire tracks in the light snow that were basically a 3-point turn right in front of 34 Fairview. That can't be. It would have registered as a triggering event, and we know it didn't happen. So he's lying. And the question is, why would he even say that, unless did the guy who interviewed Karen Reed earlier that day tell him? And, if I'm the defense, I'm bringing that out because it raises an interesting point. If you believe Matthew McCabe, which I suggest nobody would on this point, but if he's telling the truth, well, that calls into question Burgess's analysis of no, the 3-point turn had to be over here at this time. Either way, it's a mess. And it does support the defense claim that these guys, meaning the state police, are making up stories to help get her. And, you saw the other day, there is evidence in the record that's beyond speculation that would seem to establish that Michael Proctor has his dirty little fingers where they shouldn't have been. I mean, that stuff with the bumper glass the other day.
That was the next thing I was going to bring up, is just
devastating.
The demonstrative aid Alan Jackson was able to get in this time. I don't think he was able to get it in last time, or it wasn't as clean, at least, if he did get it in last time.
He didn't. And the reason is this trial, sometimes be careful what you ask for. Brennan made a motion to use demonstrative evidence. The judge allowed it, and in the process allowed an evidence which ironically, is going to potentially bury Brennan.
And sometimes that happens with, better lawyers, I would say, want to use demonstrators because they trust their own skill and ability to use that. So, but sometimes when you take tools away from better lawyers, it can level the playing field a little bit if maybe the other lawyer's not as skilled as Alan Jackson or some of these defense lawyers. But I remember him trying, and it was clunky last time. This time it couldn't have gone smoother. It was so obvious that Proctor had some other piece of glass that didn't match what Buchanan found, didn't match the cocktail glass, and was on the bumper. Weeks later, he finds this glass at 34 Fairview. It doesn't make any sense to me. And that is one of the most shocking Proctor moments to me this whole trial, if you can believe that.
It does make perfect sense to me. It feels like the most logical explanation, and certainly the defense has no burden of proof here, obviously. But if you said you could come up with some ideas of how this could happen, but what is the most reasonable and logical explanation? And as crazy as it sounds, the most reasonable explanation is that Proctor had an extra piece of glass, and he's not thinking about, necessarily the scientific evaluation of glass, and he wanted to make it look good. And you put a little glass, we know John O'Keefe was found with a glass right on the bumper, right by the rear taillight at issue, and it looks impressive. And then, you find a similar piece of glass, as you said, weeks later at 34 Fairview. And so you kind of break this down and say, well, if it doesn't match O'Keefe's glass, and it was also found outside 34 Fairview, again by Proctor weeks later, how did a piece of glass that doesn't come from O'Keefe's glass get on the bumper? How did it get in front of 34 Fairview? Why is it always being discovered by Proctor? And Brennan, you get what you pay for, has been hiding Proctor. I mean, this could not have worked out any better for the defense. It's like they're treating Proctor like, he who must not be named from Harry Potter.
Yep.
And the defense is naming him repeatedly. And every bad fact that comes up, all trails go back to Proctor. So I thought that was devastating. And, now that they're on what feels like a full week vacation in the middle of a murder trial, which is crazy to me, but I know it's Memorial Day, but putting that aside, what a horrible way to end if you're the prosecution. I mean, this is just Proctor is hanging in their head right after Burgess, right after the medical examiner. The neurologist, I don't know if the jury got it yet, as opposed to that's more a summation thing. I don't know that it was readily obvious, but they had a pretty bad week or so if you're the prosecution. I mean, they're finishing up weak. They have like no momentum, and they're essentially done other than one witness.
Yeah. And one of the other things they did this week that, I have felt like is some of their more effective evidence personally, but I wanted to get your take on it, are Karen Reed's clips from these interviews. So you talked about the 3-point turn, which I get it that it's not in dispute, but anytime you can have the criminal defendant, I love when it does that thumbs up. Whenever you have the criminal defendant confirming what you're trying to prove and what you have witnesses talking about, and you want that piece of the timeline to try to fit in on how the night goes, I think that's effective. The 12:41 call from the garage and her walking inside, they're trying to say, again, they're just ignoring 12:36. I don't know why, but they're trying to prove she gets there at 12:41, which is much better for their timeline. Karen Reed says he died between 12:21 and 12:30 as far as John O'Keefe goes. And she pulls a piece of glass out of his face and it gushes blood, which I know the defense is good for the defense if he's gushing blood. But, the defense wants to say these frontal injuries are from a fight or some kind of scuffle, which could come from glass. But I also think it could come, the Commonwealth saying he's hit with the cocktail glass and, the cocktail glass hits him in the face and that's how he got the front injuries. But I do think that the clips continue to be good evidence for the Commonwealth personally.
So it's crazy in some way, but I think 4 weeks into this and basically their case for all intents and purposes almost over, that their strongest evidence have been these out of context clips. And I don't mean that as a compliment.
Like mid-sentence, they're snipped. You can just tell. It's
well, there's more to this. This is not a compliment to the prosecution. It's just an evaluation of
right.
You need to do better, because I don't think they're that compelling, but I think they're better than the witnesses. But putting them where they start mid-sentence is a terrible look. They're clearly out of context. We'll see if they have to even choose to clean them up or not. If the idea of Brennan is to try to smoke her out of her cave, to be forced to testify, these lawyers are way too disciplined. There's not going to be any panic move to explain this. If they have to take it, they'll take it. They'll deal with it in summation or whatever. I think, again, they established, like you said, arguments that are consistent with things they're arguing, but we're still speculating that it could be this or it could be that. And the problem for the prosecution is they have the burden of proof. And if you have the burden of proof and you're trying to say, well, maybe it's this and it might be that you lose. I mean, you need compelling evidence, and I don't think they have it. But, that's why also these clips, another reason why I think the defense maybe has to think outside the box and call a few witnesses that they might not. The clip with the 3-point turn. Again, there's no issue. There's no 3-point turn. And probably it happened at the exact time that Burgess said it did, because it's in the data and whatever. And she's basically saying it. But why not call McCabe to basically establish why are they trying to frame her with false evidence? There's no way he saw it. I mean, so that really can put that clip in context as a red herring. The larger issue is the cops took that 3-point turn and they're trying to exploit it to frame her. I mean, their initial theory of the case was that the killing happened during a 3-point turn. It's one of their shapeshifters. That was one of their original theories, because they didn't have the science about it. They just knew that she admitted it. And now you have witnesses in the house saying, oh yeah, I saw the tire tracks. No, he didn't. I mean, that's just, that's absurd. So, I mean, these clips standing alone sound great, but with the burden of proof and all the other problems in the house, I don't see them as that compelling.
Yeah, and I agree, but I do think that juries love to hear from the defendant. They love
Yeah.
to hear from the defendant. I think they're going to put a lot of weight in every single word that she said. But again, I do think it is very obvious that they are snipped up, which is good for the defense. And I can't imagine. Could you imagine if he would have just played it all at once? What it would sound like? It would sound like, and I made a 3 point, and at 12:41, and it's like clipped, and then you get to the next one and the next one.
Yeah, I mean, it would sound ridiculous, but it also feels ridiculous the way they're doing it. They call a witness who gets destroyed, but I'm going to convince you with a 7-second half clip that it doesn't matter because Karen said this. I don't know what kind of impact it will have, but I think, look, we would all agree that her degree of talking was clearly a mistake, and some level of just, you scratch your head and say, why would you do that? I mean, if these clips didn't exist, I don't know where they would be. But, when push comes to shove, you go back to the real evidence in the case. There's no proof of a homicide. There's none of this. And that's not going to get the hump.
Yeah. So let's get to that, because that's kind of how I wanted to wind it back to Dr. Welcher. And let's say Dr. Welcher has a great resume. He comes and he shows with pictures and demonstrative aids and data that Karen Reed backs up at 24, 22, whatever miles an hour at 12:31 and some changes directions 12:32, drives home. And I mean, I don't even know if he'll be able to even testify that she's able to get home at 12:36. I think that's outside his expertise. But so the backup event, 24 miles an hour, leaves. He lines up and measures what John O'Keefe's arm bent would look like, and the scratches line up perfectly with the height of the taillight. And right where the taillight is cracked is where these scratches are. And he explains how, somehow the math and the science and the force is strong enough to break the polycarbonate, but not break any bones, strong enough to knock him over to hit his head. Again, let's say he has testimony that really lines all that up and shows that that is probable, or to a reasonable degree of scientific certainty that that's what he believes happened. Could it be enough in your mind to get you to think that's actually what happened?
No, not well, to me personally, I don't know. I haven't heard him, but to get over the burden of proof, no, for a couple of reasons. Number one, the ARCA people are going to say, who are going to have as much or probably more credentials and are not biased. I mean, the irony with Brennan arguing the ARCA people are biased, they come from, a third party who shall not be named in this trial, didn't know the defense. They render their opinion. The Aperture people are the ones who are hired guns. And whatever, that's how experts are. They get retained by a party, they get paid. But in terms of like natural bias, the Aperture people are going to be more biased. They're paid to give an opinion. Number two, the beginning of your analysis of Welcher still depends on Burgess being reliable. I don't know how they're ever going to get past that. Number three, the prosecution has got to have Welcher absolutely slaughter the ARCA witnesses. It can't be close because of the burden of proof. And you can't have a jury say, well, I don't know, it could be either one. That's an acquittal if they can't say. It's got to be, I trust these guys. The ARCA guys don't know what they're talking about. So they've got to overwhelmingly do that. And the problem is, amongst everything else we just said, this is not a hard science. This is an opinion science, okay? Mm-hmm. And the Aperture guys, they're hired guns. They have a problem with Burgess. They have other problems. They're going to give an opinion based on what they think. The ARCA guys are going to give an opinion on what they think. And to some extent, they're going to cancel each other. Or if anything, I would imagine the ARCA guys are going to be more impressive. And then you say, what's the hard science? The hard science is the medical examiner, that kind of thing, who's going to say, I can't tell you it's a homicide, and this does not strike me as what I've seen consistent with car accidents, as Dr. Russell's going to say too. I think they got a 2-for-1 with her, if you remember, because she was an ER doctor.
Absolutely.
Don't forget,
ER doctor.
That's right.
Thousands of car accidents.
Yeah. She's going to say, I also don't think it's really fit with a car accident. Dr. Wolf has already said there are injuries that I can't account for based on the DA's hypothesis. So you factor all of, and then you're going to get the dog bite stuff, which again, it's all part of reasonable doubt. Russell's going to say, this other doctor they have is going to say. So you look at all that and you say, how is Welcher carrying the baggage of aperture that Burgess absolutely destroyed, going to carry them over the finish line and overwhelm all of the hard science and strong opinion science that the defense has, and the Proctor issue and the other stuff that we've been talking about. And I don't see getting 12 people to say, yeah, I'm with you.
Yeah, getting 12 people is going to be tough. I do think, though, if Welcher does crush it, there will be jurors that think that it's been proven. I do think that. And before the defense's case, right? Before the defense brings up everything you just said.
Natural. When you hear one side, sure.
Exactly. But that's what you got to do as a prosecutor. You get the ball first. You better go score. And then if they come and score, you got to go score again. So I get it that I projecting what's happening, but I do think it's possible. Here's my biggest hang up on it. And if I was a juror, which, we would never be picked for a jury, but if I was a juror, the hardest thing for me, even if Welcher perfectly explained it, showed me the math, the science, and the measurements, logic and common sense are still things that jurors are allowed to use, and that we as lawyers beg them not to throw away just because some guy that says he's a doctor tells you something that your common sense says just can't happen. And in my life, with my experience, I've seen a lot of car accidents, seen a lot of injuries, seen wrongful death cases from car accidents, and this just ain't matching. And that's
I agree. I think that's a really strong point. Medical evaluation aside, you're right. I mean, we tell jurors all the time, the 3 C's, right? Credibility, corroboration, and common sense. At least that's how, a lot of times that as I'm thinking this out in terms of this credibility, those are the 3 C's, they matter. And common sense is a big one. And I'm at a loss, just as a lay person, no medical training or understanding at all, how a guy gets drilled at 25 miles an hour by a 7,000-pound vehicle and gets just nailed in the arm to the point where it's just hacked up the way it is. And there is nary a bruise or broken bone or anything. And I'm not buying that. And I think that's corroborated by the fact that there are unaccounted for injuries. There's vomit on the front of him. I don't know how that makes any sense. If he's lying on his back, there's vomit like rolling down his pants. I mean, gravity plays a role in this at some point. And I just don't know how they're going to get over that with all of the other problems that they have. And then you go back to the medical examiner, who I think did catastrophic damage to the DA's case, because in summation, they're going to say, never mind whether Karen Reed is responsible for causing John O'Keefe's death, the person who is best in position to know would not say that anybody caused his death, even when made aware of taillight pieces. I hit him. I mean, I think Brennan really screwed himself with that ridiculous stunt, and probably improper stunt, but the judge allowed it, where he basically tried to sum up through the medical examiner with all the evidence. And then she comes out and says, yeah, that doesn't change my opinion.
That's crazy.
If that's ever an own goal or a self-immolation at a trial, I don't know that I've seen anything worse than that.
Yeah, he's done that a couple of times where he's asked questions he thought he was going to know the answer to, and he didn't get the answer he wanted. And I think that that's going to be a big deal for the defense, is keeping it simple with their cases, to just say, no, that's not a car accident. Clearly not. It looks more like a dog bite injury, but it's clearly not a car accident. And that, to me, is a way that they can really move the ball down the field. And a lot of people have been trying to figure out, actually, before we get to the defense's case, Chief, one last thing. Yep. So you've mentioned all the time, or you mentioned a couple of times about, Brennan's trying to do this with these witnesses. We know what he's going to do with ARCA. Some of the stuff he's been setting up has been with questions with his witnesses, like with Burgess. Did anybody tell you what anybody testified to this trial? Is anybody passing along information to you in this trial? And he's going to use that against ARCA, that somehow, I guess, during the first proceeding, because I don't think it's happening during this one, somebody was giving ARCA information. Yet it's such an easy counter for the defense to say, did you change your opinion in the middle of this trial? No, you didn't. Your opinion is all the way back.
When Brennan at the pretrial hearing with ARCA was, in my view, making a fool of himself by swinging from the chandelier and all the histrionics and pounding the table and all the theatrics, no jury, whatever, that was all to get sanctions and like a Hail Mary to get these people thrown out. And it, you understand why he has been so trying to get rid of ARCA, not let them rebut, because he's got Aperture and he's got Burgess, and he's kind of told on himself. He knew what was coming with Burgess. He obviously, he's an experienced lawyer. All you had to do was Google. You would have seen everything. The other problem he has is the jury knows that he wasn't honest about Burgess. He tap danced around the issue. It came out on cross, which looks terrible. And then for whatever reason that makes no sense to me, he tried to redirect rather than take his medicine and close the issue, which just opened up a whole nother round of cross, which, by the way, buried the part of the redirect, which may have been effective, where he was focused on the data for an hour, but all the jury's walking around as, my God, this guy just continues to lie about his resume. So he kind of wiped that out. But I think what he also did, he continues to sacrifice his credibility in front of the jury, and it's going to hurt him when it comes to cross-examining Arca. So I've always said that I don't believe he's going to do a cross-examination like he did that ridiculous one at the hearing. I don't see it. He's too smart, I have to believe, and too experienced because of what you just said. These guys were hired at a time they didn't know who Karen Reed was. They didn't know who Alan Jackson was. And they gave an opinion based on what they were told without caring one way or the other who's involved. So whatever happened after that, their opinion has been the same. It's never changed. It wasn't influenced by bias for the defense. It's influenced by whatever they got. They made an opinion. So that's, as opposed to Aperture, they changed their opinion. It's a big difference. Those guys, Brendan is arguing, nobody talked to you, nobody told you to do this, but he's kind of burying the lead on this point. But they changed their opinion mid-trial, and it just conveniently helped the defense. Juxtapose that against Arca, trying to suggest their bias. Their people are talking to them. Yeah, buddy, but their opinion has been consistent before they ever met the defense. So what's your point? And then moreover, if he were to try the super aggressive cross of them, which I don't think he will, but we'll see, he sacrificed all his credibility by the stunt with Burgess, because he's trying to imply to the jury that whatever happened with Burgess is no big deal. And never mind the fact I didn't ask about his education. Who cares? It's all fine. Nothing to see here. And then he's going to get up and express all this righteous indignation about the Arca guys who are professional witnesses, who have had a consistent opinion. And he's going to tell the jury, those guys are sketchy, but not Burgess. That argument would work much better, to the extent it would work at all, which I don't think it would. But it would work much better if you presented an expert to the jury that actually didn't mislead about his academic credentials. And more importantly, you didn't try to hide from the jury. So I don't buy any of that stuff about what he's going to do with Arca.
So I don't know that he'll be as aggressive. I think based only because he's asked the questions to set up with his own experts. I do think he's going to ask about text messages being deleted. I think he's going to ask about people sharing information during the proceedings. I do think he is going to ask about that, which could open the door to some harassment or whatever.
Well, it will. I mean, if he's going to imply that, Dr. I think it was Wolf, the other Dr. Wolf, not to get confused, the Arca Dr. Wolf, if he implies that he deleted text messages and there's some implication of sketchy, then that door is pushed, you could drive a truck through that open door. And he'll say, because I've got lunatics harassing me for having the temerity to have an opinion that, tends to, in this case, favor the defense, although I didn't know it at the time. I mean, so does he really want to do that? I
think he's going to. And I think he's going to ask Cannoni to not allow it.
If he does that, look, he can do it if he wants, but I think if he does it, he's flailing. He's like just swinging wildly and undisciplined, which, again, it's his right to do it any way he wants. But I think any suggestion that these Arca guys are corrupt or they're paid for or they're in the pocket of the defense is going to blow up in his face spectacularly and make him look like a flailing fool in front of the jury more than it's going to discredit those guys. But
yeah, especially in a case where everybody's got experts. In this case, there's so many experts for both sides. It's kind of dumb to try to make any of them look like really a hired gun that's any worse off than any other expert. But we'll see if they do that. All right, defense's case in chief, real quick. Just some thoughts on what we think is coming. I think they're obviously going to call DeSorga, who's the data guy. they're going to call Wolf, they're going to call Rentschler, they're going to call the ME, they're going to call Russell, right? So those are all kind of guaranteed. I think they're going to call Proctor. Do you think they're going to call him?
I don't know. I mean, I think so, but they're not telegraphing, which is the right move, I suppose. But calling Proctor to me is as no-brainer as a no-brainer gets once you take the plunge to put on a case at all. I mean, I've tried many cases where there's no defense. There are cases you destroy it and just there's nothing to do here. They have, obviously you can dip your toe into a defense or you can dive in. I would dive in.
I agree.
You're calling Proctor for one reason. They hit him. Well, not one reason. The main reason is the prosecution hit him, and it opens up the argument in summation that, who wants you to know what's going on here? The prosecutors or us. We gave you this guy. That's number one. Number two, it's bad enough that they hit him, but they were dishonest about his role. Okay. Yuri Buchanan was dishonest about Proctor's role. And it's obvious that he was the lead investigator and it was his case. Number three, they just beautifully established a couple days ago that Proctor probably put some glass on the bumper, which makes it a hell of a lot more likely, to their point, that he might have sprinkled some taillight piece or at least lied about recovering it weeks later and whatnot. So I'm calling him, and the very simple reason, anytime you're a defense lawyer, you're doing, risk assessment, minimizing exposure to bad facts. Mm-hmm. And I'm sitting here thinking about what damage could Proctor do? And the way I come out is he's house money. There is nothing that guy can do, even if he's getting crossed, and Brennan can literally spoon feed him what to say because he can on cross. There is nothing that a disgraced, biased scumbag ex-trooper like that in this case can do that's going to harm the defense. So
there's two main ways I look at risk. Number one, could he give a good summation of the entire case and overview? They already did that with Buchanan. The way that they had Buchanan testify, there's nothing additional Proctor can do. Number two, he's going to deny that he did all this stuff and planted evidence. No, who cares? Everybody expects that. Everybody knows that. No cop's going to get up there and admit that he planted evidence or had something to do with a cover-up and a conspiracy. So there's no risk. You can only add to the damage that Proctor's done. And to me, they have done a lot of he who should not be named, and he's the boogeyman. In some cases, like I actually think Brian Higgins, and we'll talk about him next, they have made him sound like the boogeyman in an effective way. I really want to get that he destroyed his phone and put it on a military base and all that stuff. But to me, Higgins is more of a boogeyman than I think he will seem like if he takes the stand. Proctor is the boogeyman. Put him on the stand. He will confirm for the jury this is as bad of a guy as we have been hinting at the entire trial. I don't see a risk at calling Proctor. What do you think about Higgins?
Before you get to Higgins, one last point. Another reason why they don't have to call him, but they should, you want to have the moral authority. And I think Brendan has surrendered it. I think the defense look like the good guys and Brendan looks like the weasel hiding evidence. I mean, I think he has, and 99% of the cases, it's the exact opposite. The prosecutor says, I'm going to show you to the promised land, take me by the hand, and I'm going to lead. And I think he has surrendered that. The defense theoretically could risk yielding some of that based on the opening. I'm not going to say they guaranteed they were going to call him, but they went at Proctor.
Absolutely.
Hard. They called him a metastasizing cancer.
Yes.
And I think that's another reason that strongly favors. You got to see that through. And every time you mention the name Proctor, you're reminding the jury that this other guy didn't want to do it. Higgins, I have a little disagreement with you about Higgins. I'm calling him. I'm calling him because there are facts that they could establish, some of which are already established, that will support their defense without doing what they did in the first trial. It's not, you don't need to come in and say that, our theory is that it was, Brian Higgins with the rope study. You don't need to do that. But, they already have some pretty interesting things to support them. You have, that bizarre text message exchange, including messages he sent at the waterfall. You have the video that they didn't use at the first trial as effectively at this one. something's going on with Higgins.
Well, why let him explain that it's not, that they were messing? Why let him explain all that? That's already all in.
Because I don't think his explanation will make much sense. He's clearly agitated. He's getting held back by Chris Albert. Okay. And I also think then you have that message after. Are you coming here? You have the fact that he got a lawyer, which as lawyers, we never criticize witnesses for getting lawyers, but he's supposed to be the clean one in all of this. And he's saying, I'll talk to you at my lawyer's office. You can grill him on the text messages on why he went to his buddy at the FBI and selectively gave text messages, but destroyed his phone. That's big.
I agree. That's the one big thing that they don't have in evidence. That's the only reason I would call him, would be to talk about the phone situation, which does sound very conscious of guilty.
The butt dials, have not fully come in. And let's be honest, neither one of the Bryans, for lack of a better term, has given a credible answer about how it came to be that they had the only recorded butt dial conversation in the history of cell phones, the way they were doing it. I think it's also very important, the butt dial, for another reason. It's at 222 and 223. They have a big theory about what happened at 227. I think you want to tie that there are multiple parties doing weird things at the same time. Jennifer McCabe is allegedly, checking on how long to die in the cold. Then you go back to the Sallyport video that they didn't have not the Sallyport, the Canton police.
Yeah.
Higgins testified at the first trial, I went to move cars.
Right.
Well, not really. Not really. He went into another car and clearly got something. I think he might have moved one car a few feet or something, but it doesn't really comport with his testimony. And there's another big fact. At the first trial, the prosecution argument, because again, the defense went very hard that he had to have been killed in the house. And so what they did at the first trial, they called what felt like 25 witnesses, every single person to a man and woman. No one came in the house. No one came in the house. And they were able to say, look, they're all lying. They're all lying. Not in this case. In this trial, Jennifer McCabe, that's it. They don't have that amount of witnesses. But Higgins has admitted previously a guy did come in the house.
That description.
Somebody did. And he was 6'2" or something like that with brown hair. Now, he would not say it was John O'Keefe, whatever. The point is, a man who just happens to be the same height and, general appearance as John O'Keefe, according to Higgins, went in the house. And it enables an interesting argument. Number one, Jennifer McCabe is lying, which, I don't think that would shock anyone. But she doesn't have to be lying either. Maybe he went into a different portion of the house that Jennifer McCabe didn't see. But for whatever reason, because Brennan is not calling anybody with the last name Albert in this case, which is a risk, but whatever, I understand that more than Proctor. I
agree. By the way, if I was Brennan, I'd take my medicine on Proctor, ask him a couple questions, let them crush him and cross and move on.
Right. But the point is, if the defense establishes through Higgins, a guy matching John O'Keefe's description came in the house, and the only pushback the prosecution has is Jennifer McCabe, the one who changed her story about the timing of the text messages and says, I hit him, yet it's not documented in any other statement. That's a tough sell. And that just reminds me of another reason why they should call Proctor, by the way. They need to finish the impeachment of Jen McCabe. She's a difficult witness. She denies saying things that are absurd on her face. I mean, she's saying, I told the grand jury I hit him. It's just not there. I told every cop. It's not there. Proctor isn't going to change what's in his report. He's going to say, she didn't tell me that. Mm-hmm. And if he does say that.
Yeah, that's good. Yeah, you're right.
And if he does, then you're like, this guy's still lying. Mm-hmm. Another reason to call Proctor, I hate to go backwards.
No.
Is we learned something in the pretrial hearings. Proctor became the useful idiot for Brennan and Lally as it relates to the prosecution's egregious suppression of the video.
Yeah, right.
Basically, they threw him under the bus and said this dope took all the video
Put it in the file.
Stuffed it in his back pocket for 2 years and told nobody. You know what? I'd love to ask him about that. I don't even care what the answer is.
I agree.
Might he disagree with them and say, no, I gave it to this guy, Lally?
Yeah.
Who cares? Or he's going to say, oh, yeah, I'm a trained homicide detective, and I just, who needed video of the car in the Sally Port that showed the taillight? So,
yeah, you can't miss on that. All right, what about, it sounds like you would call Matt McCabe to say three-point turn stuff.
I would call.
I don't think he can hurt you as the defense, right? Like, because he didn't see anything else.
I'm calling him for a couple of reasons. Number one, and I think the three-point turn, I don't know that I would have cared about it until Burgess made it, the center of his timeline. But there's more to Matt McCabe. He's part of that ridiculous text chain about, oh my God, they're searching for evidence. They're at the Asian house. I'll go do a drive-by and take a picture. This is really weird behavior. And by calling Matt McCabe, it gives you another example to revisit an issue that, again, I think finishes the impeachment of Jennifer McCabe. And that relates to Jennifer McCabe's text messages with Kerry Roberts, where, oh my God, John is gone. How are we going to survive? But look at the family chain.
Yeah.
Don't tell him the guy went in the house. Oh my God, she's telling him everything. There's no remorse or concern about John O'Keefe in the inner sanctum of family, right? I mean, I don't want to compare it to like the mafia, but this is family. Kerry Roberts was a wild card that Jennifer McCabe was trying to lure in. So it helps with that. The other thing, which is really interesting, Matt McCabe is the only other witness who, other than Jennifer McCabe, who claims to see the car and see it move up and talks about other things that parrot what his wife said.
Yeah.
He also works for an IT company.
Yeah. Interesting
point.
Yeah.
So, yeah, I'm calling Matt McCabe.
What about any Alberts?
Yeah. I would call Brian Albert. Now, he's a little more of an interesting question because of this whole cast of characters. Ironically, maybe it's his experience. He presents the best.
I agree. And you kind of already got some of the biggest stuff out about the fact that he didn't come out of the house. He didn't care to come look. He didn't talk to anybody, whatever. You've gotten a lot. The butt dials, I know you could get into more, but
the butt dials for sure. But I have other interesting questions. I mean, look, if they're going all in on Chloe, then I have questions about Chloe.
I feel like they've gotten enough personally for what they're trying to do, but that's just me.
Different issue. I don't mean the bedroom. I mean, are you a dog guy?
No.
Okay. I don't know if there's jurors who are. Dog people would be honed into this. And again, I don't know. I mean, that would have been something on jury selection I would be probing.
Yeah.
But dogs wake up when things happen.
Mm-hmm.
Okay. But more importantly, even if you believe the dog didn't wake up at all this, there comes a point the next morning where there's an incident happening at 6 o'clock. Everyone in the house is up. They're downstairs. All these people are in the house. The cops, there's like 5 or 6 of them. Dogs wake up. They don't wake up just because there's noise, but there's other things going on. They're hungry. They need to be fed. And more importantly, they need to go out. And what I want to know is why no witness at the first trial or this trial has ever said at any time while they were huddling in the foyer of the house, you mean to tell me the dog is nowhere? Nobody took the dog out. Nobody saw. I mean, these are things I want to know with him. And, I also want to get into the fact, not just the butt dials, there's something more important. And again, you're trying to link him and Higgins. You have the video where they're doing strange things to each other, whatever, and with Chris Albert. But isn't it an amazing coincidence that he too dumped his phone the day before he got the letter? And the more that you attach these people together, and I don't want to use the word conspiracy, but they're doing weird things that make no sense, I think that moves the needle forward for the defense.
Yeah, I don't know. I mean, I think that there's an opportunity to simplify it and still keep it out there from what they've already gotten into, especially with Higgins. To me, Like, I know in my mind, Higgins came off so much worse this trial than last one. That's just my mind. I don't know if that's
They've done a
how
nice
you see it.
job of making him look like something's wrong. I mean, look, in my view, what I would do if I were the defense, and this is really unorthodox, it's outside the box. They probably wouldn't do it, but I would start with the ARCA witnesses. I would come out strong because you've just heard Welcher, you've just heard Burgess, and I would come out and, in essence, establish with the jury there's no accident here. Like, there literally was no car accident. And to me, if you get the jury already to say that's possible, again, they don't have to believe it, but just say, wow, what a lead in to Proctor that is. Because by doing that, the taillight stuff goes from, you got to be kidding me, right? Who wants to believe that, to, well, if there's no car accident, how did the taillight explode and end up all over the place? And this guy found it weeks later and there's glass on the bumper. If you do ARCA and then Proctor looks 1,000 times worse. And then when you have Proctor dirtied up and the taillight theory being planted has a little more weight, now you call people like Higgins, you're looking at him with a little dirtier eye. And then you finish up with the dog bite, the medical evidence that they have. I don't know how they're losing.
Yeah, I mean, I think based on what we're projecting, they have. The last one I just want to ask you about, because I would not call him, is the snowplow driver. Would you call him?
I would.
He's calling everybody.
Oh, well,
a bigger case than the Commonwealth.
I think the mistake they made, for whatever reason, the first time, I don't, I wasn't privy to any of this, obviously, but the defense was fast and quick, and one could speculate. I guess they thought, we have it. Maybe if you're going to do a defense, I get it.
I would definitely do more than they did last time.
Here's why I like the tow truck driver. All right,
real quick, before you tell us about the snowplow, the reason I wouldn't is because they already got in that he told Buchanan he didn't see a body at 2:30 or whatever. He didn't see a body at 2:30 or 3:30, whatever the time was. And you didn't get any of his credibility issues really out. I don't think Brendan really asked Buchanan about, well, he didn't report this or whatever, that they are going to get out if you call him. So that's the reason I feel like
the plow truck driver is interesting because, number one, he's earnest. Okay. I mean, whatever. If there's timeline inconsistency issues that were kind of revealed to some extent, I get it. That's the risk. But you look at him and you say, the guy is not lying. Now, could he be mistaken? If I were the defense or the prosecution, that would be my line of impeachment, is that he's just wrong. But he's earnest. Number two, he's no enemy of the Alberts. He worked for one of them. He knows them. He's not trying to jam them up. Some of the other evidence, though it didn't come out with the plow truck driver, is that he drives this truck that is called Frankenstein or whatever it is, and it lights up the whole neighborhood. And he's telling you, I never saw a body. Whatever time he made the pass, he never saw the body. And the reality is this. He can screw up the timeline if that's what he does. The reality is this. As long as he says, I plowed after 12:30 something and made 2 or 3 passes and there was no body there, that blows up the prosecution theory to the extent the guy has any credibility, because their theory is he's lying on the lawn at all times from 12:30 to 6 the next morning. And if this guy is saying, I saw the yard, it was lit up and there was nothing there, again, I don't know that that's damaging me. I would do it.
Okay. Anybody else you would for sure call that I didn't ask? And there's Green, Richard Green. I don't know if they're going to have to call him with the Sorga. I'm not really sure. I guess Richard Green might be the Google search expert, which they'll call for that.
They call him. He wasn't that strong the first
I agree.
So, I mean, I'm talking like presentation wise. So I think for him, the command decision is you got to be tougher, just demeanor wise.
Yeah.
Again, don't change your opinion unless it's
sure.
But just be stronger. But I think also, if he says it's my opinion that the search is at 227, and any value that he mucks that up is good for them, because that's another issue the prosecution has to have. But I think he has other value as well. There's no evidence that Jennifer McCabe, not just the search, deleted everything up until 9 a.m. and then just stopped. The other thing is, in his opinion, she deleted one message out of or one search out of like 4,000. Now, I think that prosecution experts said it was actually 4 or 5. Not that that's much better.
Yeah.
So that's a problem for them. And I think the other thing, which is interesting, and I believe they could get it in through him, Jennifer McCabe Googled herself during this time.
That's a big Koberger. I don't know if you heard anything about the Brian Koberger case, but that's a big thing for him. He Googled himself before he was arrested.
That's what I'm talking about. She Googled herself. She Googled herself and John O'Keefe in the same search engine way early. I don't think it was like 2 a.m, but when stuff had not yet gone crazy. And this is entirely consistent with that family chain. That's not out of concern for John O'Keefe. That's out of concern for myself. Am I going to get named in the press about this?
Yeah.
And you know what? She can't. They didn't ask her about it, so she can't say anything about it. And Green could get it out. So yeah, I would call him for sure.
Yeah. And I can't think of anything else. Those are just kind of the ones I had listed that I was thinking. I've heard Stonebridge's name. I don't know if they're going to call her. They really hyped her up like she was the real. I don't know. Is that their ME or do they have a different ME?
No, she's a neuro, I believe.
Okay.
They do have an ME who I believe, based on the opening, is going to say that there is no hypothermia as a cause of death because there's no frostbite. So I would do that. I mean, anything that adds to that. The only other witness that comes to mind that I would potentially consider is the next door neighbor, for the very simple reason that they did come out of the house. And you know that because they have pictures of all the craziness going on.
Oh, okay. I didn't know that.
In those pictures, you can actually see the fire hydrant and the flagpole way off to the side. Point being, the incident is much more in front of the Albert house than the neighbor's house. But these people came out at 6 a.m, and it's just like, why didn't the Alberts if it's closer to them? The other thing that you may consider calling the neighbors for is that the prosecution theory has to be that if Karen backed up 60 feet, 90% of the incident, if you will, had to have occurred in front of the neighbor's house. The slamming it into reverse would have had to occur in their house. And did you hear anything? No. And then the other thing you could ask them is, was there ever a time that the state police and the Canton police knocked on your door and just said, did you hear anything? Did you see anything? Do you have any video? And if the answer is literally at no time did the police come here, that's pathetic.
Yeah, I agree. Which I think is the answer, right?
I think that's the answer. If that is the answer, I'm calling them.
Yeah. I mean, it's going to be really interesting. And I'm glad we talked about that last part. I didn't know it was going to be so in depth. So I'm glad to see like the different ways of how you can look at it. And the ones that I would really probably push back on more are the ones I think can hurt you. The neighbors, I don't think can hurt you very much. Even the other people inside the house, like Matt McCabe and Albert, I don't think they can hurt you that much. Higgins would be the one that I think would be the toughest decision for me because I do think you have some bangers you can get out of him, like especially the destruction of the phone and the butt dials. But I also think, man, in my head, I'm like, man, that guy is shady. That guy. And the defense, I would be like, oh, the defense, if I'm a juror, the defense didn't call him obviously because he's the one they think did it. That's why they didn't call him, but the prosecution didn't call him either. So I think there's just possible scenarios for jurors.
Here's the other wild card. The first time Higgins showed up with his lawyer, like hovering over him.
Yes.
Would he do that again? Because what a terrible look for the prosecution if he literally gets called as a defense witness and his lawyer is like, lurking around the courtroom. And at one point, he needs to talk to his lawyer.
Yes.
It's right, but would that be a bad look?
Yes, that would be tough. Well, Mark, thanks for joining me again, man. I'm sure we're going to talk before the case is over to see how the defense does. And then post-verdict, we'll probably have to talk again. So I appreciate you coming on, taking the time. Till next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode So until next time, this is Peter Tragos, the lawyer you know.